Welcome to Middle Class Matters, Business News in English from Dr. CMA MV Allegation. Part number 6 of the Supreme Court Committee on Adani issue. Committee's conclusions. SEBI, Securities Exchange Board of India, point number 35. At this juncture, the committee wishes to emphasize that having systems such as ASM and GSM in place is not only the solution. There has to be actual and real prospect of the individual investor becoming more aware of the heightened surveillance. Increasingly, the stock trading is almost entirely digital even at the customer's end, and it should be possible to make relevant and pertinent information available at the point of transaction. Two significant online brokers, viz. Zerdo Broking Limited and Paytm Money Limited, representing about 24% of the total clients, are said to have implemented measures to alert clients about stocks being on ASM or GSM at the point of entry of orders. This should become norm rather than represent exceptions. Point number 36. More importantly, one must bear in mind that the securities market is meant to function on the premise of investors making informed decisions. Right since 1991, when the Controller of Capital Issues has abolished and replaced by Securities Exchange Board of India, the approach to the market has been that one must regulate the quality of disclosures available to the investors and enable investors to learn how to take informed decisions. Therefore, it is imperative that the regulatory framework must function on the basis of information being available to the investors, information being easily accessible, and information presented being capable of analysis. Point number 37. The committee notes that the disclosure-based regime can be broadly classified into the following two heads. A. Disclosures to be made at the time of issue of capital or offer of securities to list securities through a prospectus governed by the SEBI Issue of Capital and Disclosure Obligations Regulations 2018 ICDR Regulations. B. Disclosures to be made after listing during the course of operations of a listed company to intimate material events and developments and other statutory disclosures governed by the SEBI. That is Listing Obligations and Disclosure Requirements Regulation 2015 and the SEBI Prohibition of Insider Trading Regulations 2015. Point number 38. Under both heads, there is an urgent need to introspect and take a hard, close look at whether there is a surfeit of disclosures that loads and burdens the investors with so much data and noise that the real content necessary to make an informed decision may be lost. Point number 39. Offered documents and prospectus issued at the time of listing in compliance with the ICDR regulations run into several hundreds of pages, which begs the question as to whether investors actually read these documents. Point number 40. Upon a request from the committee, SEBI presented a chart comparing the annual disclosure requirements in the United States with the disclosure obligations in India to empirically demonstrate how India entails more disclosure than the United States. The document of comparison is placed in the compilation of submissions and would show how we have far wider and far more expansive scale of disclosures is stipulated in India. This leads to noise and clutter that makes it burdensome and difficult for the investors to get to the core messaging that is needed. For instance, SEBI has stated that while only material related party transactions are required to be disclosed in the US, in India, every related party transaction is required to be disclosed. IEPFA, point number 41. The committee is of the view that various imaginative and creative measures can be easily attempted by the IEPFA, such as A. The integrated portal announced in the Finance Minister budget speech should be expedited, and process re-engineering delegation to the issuer companies based upon type and threshold of the claims must be considered. B. The same may be reviewed on incremental basis from time to time, considering the benefits on reducing the timeline for disposal of claims vis-a-vis the risk of frauds. C. Pilot projects such as taking up names from the death registry in a given area to map it with the database of the IEPFA and proactively attempting to reach out to the next of kin should be considered. D. Registered market intermediaries who are answerable to the regulatory regime of financial sector regulations could be identified and recognized as agents for service delivery to enable release of unclaimed dividends and securities. E. An officer's strength of a dozen personnel is evidently disproportionate. The IEPFA would need a full-time chief executive officer who could have specific key performance indica that would be fixed by the governance oversight of the authority. Point number 42. The government of India ought to give its active consideration to provide for a centralized authority to handle and process unclaimed private assets on the lines of suggested for creating the Central Authority for Unclaimed Property. Unclaimed assets can emerge from various segments of the financial sector, be it securities market, insurance market, banking sector, pension sector, or any other such avenue in which living individuals would invest. The need for a centralized holistic approach must be recognized. The temptation, if any, to absorb assets belonging to members of society to the wider public exchequer must be shunned. Such an agency has to be a full-time, hands-on, real-time, proactive agency that activity seeks out to discharge a mandate of reuniting assets of dead individuals with their successors. Financial literacy. 43. Finally, the committee believes that there is a vital need to introduce financial literacy as a matter of pedagogy right from school curriculum. Financial security of a society is as vital as national security for a society to be robust. Right through school and university curricula, there is a need for regulators to engage with educationists to bring in a culture of financial awareness and literacy. India has for a while been the third largest economy in the world in purchasing power terms, and the education our society gets must be commensurate with such standing. Earnings, savings and investing, earning returns and giving back to society are part of a virtuous cycle, and the era of treating money with an unstated element of stigma must not continue. Imparting appropriate education about the right role of money and how individuals should handle money is therefore an important element of education to impart. This comes to the conclusion of the chapter number 3. We will continue in the next video on the chapter number 4. Please like the video, subscribe to the channel, give your comments. Thanks for watching.